Good morning, everyone. My name is Julie Littlejohn. I am the business manager for AusCham Cambodia. The Chamber is delighted to again be partnering with Tillett and Gibbon, along with our colleagues at AusCham Laos and Myanmar, for this third webinar in our legal series on the important subject of anti-corruption and internal investigations. We have 5 speakers presenting this morning. Maurice Burke, partner at DLA Piper. From Tillett and Gibbon, Michael Ramirez, counsellor at the Bangkok office. Jay Cohen, partner and director from the Cambodian office. Dino Santeliello, head of Laos office, and Dr. Ross Taylor from the Myanmar office. There will be a Q&A sessions following the country's specific presentations. Please post any questions you may have in the chat box. We will start with a presentation from Maurice on considerations for Australian companies in Southeast Asia. Maurice heads up DLA Piper's Asia investigations practice, widely recognised as one of the leading dispute practitioners in his field. Maurice has advised a broad range of multinational clients on successful strategies that meet their commercial goals. With over 20 years of experience in the Asia-Pacific region, Maurice understands the market, its legal systems, and how best to navigate through them. He understands regional problems and can represent you in dispute resolution, investigation, and in contentious regulatory matters across the region, including Indonesia, Vietnam, Thailand, Malaysia, and the Philippines. I will now pass to Maurice.
Good morning. Thank you very much. It's a pleasure to be speaking to you this morning. My name is Maurice Burke. As mentioned, I'm the head of investigations at DLA Piper for Asia. My sort of story that's relevant to this presentation this morning, I moved to Singapore from Hong Kong in about 2001 to work on an investigation for, at that point, Rio Tinto and BP. And essentially, I've been doing investigations and compliance work ever since. Southeast Asia has very much been the focus of my practice during that entire time. I'm going to speak to you for about 10 minutes at a very high level about some of the particular risks associated with operating and investing into Southeast Asia, particularly from an Australian corporate perspective, and some very high-level suggestions as to what you should be thinking about in terms of your compliance systems and how to avoid and when necessary, detect those risks. So, looking at compliance risk in 2021, and I'm very lucky to be working with compliance teams, investigations and audit teams at a number of different corporates who are very much the front line in terms of dealing with these issues. I think my experience suggests that where the big risks are in 2021 are these 4 categories that I've mentioned on the slide. Corruption, which is not a new issue by any stretch of the imagination. A couple of new buzzwords that everyone is keen on, ESG and RBC, and I'll speak about those a little bit. I'll talk very briefly on cyber risk and speak about the impact that COVID has had on compliance and risk for corporates operating in the region. So to talk about corruption, it is not a new phenomenon. It has very much been an issue in Southeast Asia, for a very long period of time. It's always important, I think, for us to remind ourselves that corruption is definitely not a Southeast Asian phenomenon. Corruption is basically everywhere, and we see countries in Southeast Asia who are actually doing a good job of reducing corruption risk and the reality of corruption in their jurisdictions. Some countries are going forward in that regard. Some, I'm afraid, are going backwards. And I think you will see the excellent presentations coming up dealing with individual jurisdictions very much on that point. In terms of the sort of core propositions for compliance teams, one of the great challenges that I see that compliance and investigations teams facing is the challenge to balance the core compliance propositions, often coming from head office, and balance those with the need to localize their compliance systems. It is essentially useless to get the big book of compliance and deploy that from head office and expect that it's going to have any effect in diverse jurisdictions such as Laos, Cambodia, Vietnam, Indonesia. Correspondingly, compliance teams basically go mad if they attempt to localize all of their programs such that they're very, very specific to the jurisdictions that are relevant there. So compliance teams have to find a balance in relation to this. And the question is, how do you find that balance? I think the answer is when you can assess that non-executive personnel in your operations in country are getting the compliance message, can understand that, but your central compliance teams still have real control and the real ability to review what's going on, then you're getting close to the necessary balance. Buzzwords: ESG, RBC, environment, social, governance, and responsible business. Very much this has become a critical part of doing business. Corruption is a risk and an age-old risk, but failure to properly govern your business, or to be responsible in the manner in which you run your business is frankly more of a threat in terms of reputation, business partners, and just sort of market standing. It is an enormous topic, and I can't cover it in any way here. My point, I think, is that corporates, Australian corporates in particular, should be mindful that a heavy layer of responsibility has been placed upon management and compliance in bringing in these concepts. And what I'm seeing and what I think compliance and management are concerned about is a dilution of the focus on some more traditional risks such as corruption and fraud. So OECD has recently done a survey, and it's a survey of operations in Southeast Asia, and they say 61% of those who responded say they have effective anti-corruption policies in place, but only about 50% say that they feel that they have effective broad-ranging ESG and RBC type policies. So there's a lag, and what I think that lag is going to create is a pivot away from traditional risk such as corruption and maybe a move towards the more sort of environmental, social governance, which is a good thing, but compliance resources are finite. And often already stretched thin. Cyber risk, a giant, fascinating topic. It's a reality in Southeast Asia. Any business and any people within that business operating in Southeast Asia are exposed to significant cyber risk. We see cases of email compromise. We see cases of e-commerce data interception. So, the ability, how businesses order product, how businesses pay for product, that data is being intercepted and is being abused, and companies are finding themselves defrauded. Lots and lots of relatively straightforward scams where scammers are impersonating government officials, seeking information, seeking money, etc. A few cases of ransomware, particularly it seems in the life sciences space, which are more serious, but the bulk of what we're seeing in the cyberspace is reasonably run-of-the-mill e-commerce data interception, email compromise. Ensure your systems are up to date. Impact of COVID, and we get asked this question a lot. I think there's two ways in which COVID has changed the risk profile. One, some specific COVID-related frauds, such as individuals impersonating government officials or individuals proposing to sell healthcare type products. Companies under the stress of COVID, particularly in the early part of last year, were making bad decisions that they probably wouldn't have made in normal times, and so businesses found themselves defrauded. Maybe more sinister and maybe more insidious is how COVID has changed the way we live our lives has also increased risk. So information systems, the necessity for people to work from home, compliance teams being stretched very thin with new risk. All of that has opened businesses up to greater risk, and we've seen many cases where the way that businesses have had to change their operations to deal with COVID has created fraud and other regulatory problems. So against that sort of slightly sinister backdrop of problems, what can you do? In thinking about these slide presentation, it occurred to me that what we're really looking at is some really old stuff and some really new stuff. And it's tempting to say that everything old is sort of new again. But I think the good news, and compliance teams and management teams and audit teams are figuring this out, is that the sort of core tools available to fight the new risks is basically the same set of core tools as it's always been. So policies, localize your policies, make sure that they are translated into local language, make sure that they're sensitive to local law, and make sure that they're sensitive to local culture. Doing that across the whole of Southeast Asia does create a challenge for compliance teams. And as I mentioned earlier, there has to be a balance. But if that balance can be found, you'll have individuals in your business, in your investments, in your businesses in Southeast Asia who are compliant, compliance aware. Empower the local people. It used to be very cool to talk about tone from the top. I am not a fan of tone from the top. Some grey-haired guy sitting in Minnesota speaking with great seriousness about compliance has rarely been an effective way to convince, for example, Indonesian workers that fraud and corruption are bad things. Tone from the top is important. You have to have it. But what I think works better is to manage from the middle. The real stakeholders, the real business people who are going to make a difference are middle management in country. If those individuals truly get the compliance culture and understand the systems, your chance of getting the local working population to care about compliance goes up exponentially. And remain vigilant. Compliance is not a static business. Constantly update your systems, constantly review to see whether they're still compliant with local law, and constantly see whether they're working. Business partners. Most of the serious issues that we see arising in sophisticated corporates, particularly Australian corporates, aren't internal, they're about business partner relationships. So whether those relationships are upstream or downstream, great risk is there. And it's particularly risky when it comes to ESG and RBC, because you're going to be held accountable, not just for their corruption activity or fraudulent activity, you're also going to be held accountable for their failure to comply with ESG standards. Companies, I think, are deciding that what you really need to do is be part of your business partner's business. Be an actual part of it. And I think compliance teams and management are seeing two ways to do that. The soft way, where you work with them, you work cooperatively with them and understand their business so that as it supports yours. The hard way is to impose, for example, unannounced rights of audits, the ability to just turn up and audit their businesses, essentially raid your business partners. The carrot and the stick approach, the preference in business, of course, is to be cooperative, but the activity of your business partners is absolutely critical. And so you need to be watching them. Again, it's not a static process. Lastly, your people. Time and time again, we discover that the major investigations where we see serious issues, they come from someone who is offended by the conduct of another person. It is always whistleblowers who are bringing the big issues to our attention. It's not internal audit, it's not clever software, it's always people. So treasure these people and rest assured, and this has been my experience, that there will always be more people in any business who care about corruption than are ready to do it. So treasure your people, work with them, build a compliance culture in their minds. I've gone past my 10 minutes. I hope that's helpful. I will hand back to Julie, I think, to proceed with the rest of the presentation. Thank you very much.
I would now like to pass on to the country-specific presentations. And we start with a presentation from Michael Ramirez from Tillett and Gibbons Bangkok office. Michael Ramirez, Counsel in the dispute resolution group of Tillett and Gibbons Bangkok office, assist major international clients in a range of domestic and international disputes, including product liability, employment, customs and excise, and transportation and logistics. Michael serves as a client advisor on the strategic aspects of claims management for international litigation, cross-jurisdictional disputes, and compliance with local and foreign anti-corruption laws, including the Foreign Corruption Practice Act. Thank you, Michael.
I thank you, Maurice, for the very, very helpful introduction. I'm not going to belabor some of the very, very good points that Maurice has made, other than maybe just a couple of points. One is what Maurice says about the general brevity of our presentations today and the real complexity to these issues is absolutely true. It is just, even in a 30-minute presentation as I'm giving now, impossible to cover all of the salient issues that may arise for companies who are considering the conduct that investigations, post-investigation compliance, etc. So purposefully, I've tried to keep the slides minimal. I've tried to make sure that the points that I make, and they're my points, are as direct as possible, as general as possible, and I will try to fill in here and there. It's one thing to say that where there is wrongdoing within an organization or on the periphery of an organization, that there should be an investigation. But at the end of the day, it's ultimately a decision that has multiple inputs on whether first to even conduct an investigation, to plan an investigation, and whether to what extent that investigation should be conducted, and ultimately what should be done. So it's a very, very challenging decision for businesses. We're not just talking about global multinational companies with massive resources and their own compliance officers, but also SMEs. And frankly, SMEs are oftentimes just as affected, if not more affected, by some of the regional issues and pressures on their organization, on their employees, and yet they don't have the financial wherewithal of multinationals to conduct an in-depth investigation to the extent that, say, maybe some of their competitors would be. So it's a real challenge, and that is, I think, what most important thing to concern is various situational inputs for companies. A company might be an SME, might be a regional company. They may not have the benefit of global counsel. They may not have the benefit of outside global anti-corruption counsel or white-collar criminal counsel, and they may not have the resources. So I'm talking to everybody, but I'm also cognizant of the fact that resource allocations are different from company to company. So having said that, I want to talk about internal investigations. And essentially what I'm talking about today is, what are the investigations? When do you make a decision to conduct an investigation? And how do you conduct that investigation ultimately? And what do you do post-investigation? So an investigation, broadly defined, is an organized, in-depth evaluation of facts and evidence conducted by a corporate entity, the business entity, often with the assistance of independent outside parties, and I'll talk to that a little bit later, resulting in specific report findings and frequently recommendation on actions. So just a point here, it's not always that an investigation, and when we think about investigations, we oftentimes think of anti-corruption, the stuff you read about in newspapers or on the internet that lead to multi-million-dollar fines, and those are the type of investigations that might have many inputs, several engaged outside counsel, maybe forensic experts, etc. But not every investigation rises to that level. That doesn't mean that they're not equally important, and it doesn't mean that they may not have liability implications for a business. So what are we talking about when we're saying internal investigations? Now, I know that we talk broadly, and Maurice talked broadly about anti-corruption, but investigations run the gamut. Now, this is not even an exhaustive list of types of investigations, but this is the kind of stuff that we have seen through the years. Employee-related wrongdoing. It doesn't mean that it's corruption related. It can be theft. It can be violation of corporate policies, rules, other types of wrongful behavior that have implications on an organization. So sometimes an investigation might be of a scope to just internally review the wrongdoing of an employee and assess whether or not there are liability implications and whether or not that employee should be terminated or encouraged to resign, etc. Third-party wrongdoing. Maurice talked briefly about the importance of working with your business partners in a way that allows you to monitor and participate in their activities. Sometimes not enough is done, or sometimes you might have anti-corruption clauses in agreements, but there isn't a lot of daily interaction just because of the nature of the business. And there is third-party wrongdoing that has affected the organization. There's the traditional corporate malfeasance instances where you might have management level employees doing wrongfully or engaged in wrongful activities that have implications on the organization, on its shareholders, its employee, and on the reputation of the company. There is traditional anti-corruption, and in this current COVID environment, I think there's a palatable threat for new areas of corrupt activity. This is not just the traditional anti-corruption activity, for example, of bribes to government officials, etc., but maybe private corruption, price fixing in procurement bids, things of that nature. Other civil and criminal wrongdoing, basically a number of different white-collar criminal actions. And then finally, ethical and human rights violations. So they may not necessarily have significant criminal implications or liabilities, but they could have real reputational effects on an organization. So as you can see, there are a lot of reasons why a company might want to consider an investigation, and in some cases, the very nature of that wrongdoing, which, as Maurice said, usually comes via whistleblowing activity, and that's our experience as well. It's most always, well, sometimes from internal audits, it's almost always because somebody has said something. And so when you have that, whatever type of wrongdoing you have experienced, you have to make the decision on what are we going to do. Typically, that means actions that are conducted quickly, but organized and scoped in a way that are going to be productive and useful to the organization. So what are the stages of analysis when it comes to conducting an investigation, or whether you even choose to conduct an investigation? Well, first is to identify the actual need for the investigation. And I alluded a little bit to the various inputs there. Once you've identified the need for the investigation, part of that process also involves assessing the pros and the cons of conducting an investigation. And there are numerous pros, and there are also cons that need to be considered. And sometimes those pros and cons have a significant effect on whether the company itself will proceed with an investigation. What is going to be the scope of that investigation? Not every investigation involves hundreds of thousands of baht or thousands and thousands of dollars of investment of time and resources. Sometimes it's a narrower scope that is allowed given the given situation. So the scope of the investigation will dictate costs, will dictate the number of persons involved, the entities involved, etc. The actual process, this is the investigation itself, the organizing, the strategizing, the conduct of the actual investigation. How is it going to be determined? Ultimately, what are the timelines? How is it going to be concluded? And how are you going to deal with some of the very real issues and impacts that an investigation causes on an organization and its employees? And we'll talk a little bit more about that. Finally, at the end of an investigation, typically whether you have outside counsel involved or not, you're going to have reporting of the findings, and very often, in almost every case involving outside counsel or third-party experts, recommendations for the firm or for the corporate entity. Recommended actions, recommended compliance actions, recommended terminations, how to go about those terminations, garden leave, a number of different possible recommendations, all with the focus on the best outcome for the company in dealing with this existing problem, but also moving forward in a way that limits liability and preserves reputational position. And then finally, the post-investigation actions. Again, Maurice talked about compliance. I would just say this on post-investigation actions, whether they be terminations or post-investigation compliance. Many companies, including SMEs, have very, very good compliance programs, brochures. They communicate reasonably well to employees. They may be prepared at a global level, but it may not necessarily be adapted well enough or in an effective way to deal with every jurisdiction in which they operate. As Maurice said, working in Malaysia or Indonesia is very, very different than working in the United States or on the Gold Coast of Australia, or certainly even other parts of Southeast Asia. And so it's very, very important to understand not only the local laws, but local customs and approaches. Otherwise, compliance programs and communications and actions aren't going to be nearly as effective as they might be in another jurisdiction. So sometimes that is a missing component for a successful actions post-investigation. Okay, identifying the need for an investigation. Very, very important to understand first, is there even an obligation to investigate? In some jurisdictions, there are statutory or regulatory requirements that put a company in a position where they conduct an inquiry or they conduct some level of investigation. There may also be, and this is much more common, company rules or policies, internal rules, either through the compliance group of the company or through just the company management itself, that dictate how an investigation shall proceed given certain wrongdoing. Typically, that might be employee wrongdoing. So most companies have in place, for example, a policy for conducting an internal investigation for employee wrongdoing or malfeasance. But it may not apply in every situation of potential wrongdoing or corrupt activities, etc. So sometimes there's an overlap of what the company rules and policies require and what might actually be structured for a more comprehensive or more focused investigation. It's important to be mindful that you are taking into account both. If you are going to make a decision, a discretionary decision to go beyond simply what the company rules or policies require. And so if there isn't a specific obligation or if there is a minimal scope obligation, then the issues become discretionary, as I mentioned, which is essentially, shall we conduct this investigation anyway? What are the interests and what are the interests in conducting this investigation? Well, they start ultimately with what is the scope, how broad, how significant, and what is the nature of the misconduct? What type of misconduct? So clearly some types of misconduct give rise to a very, very important and broad scope investigation. Anti-corrupt activities, payment to government officials in a procurement bid, for example, price fixing, that kind of stuff. Whereas maybe employee theft, well, very important and certainly significant, may not give rise to the level of and scope of investigation, but nonetheless an investigation. So it's important to understand exactly what the scope and the nature of the misconduct is. And what I would point out here is that you don't always know. In fact, in most cases, you do not know the full scope and nature of misconduct. You've had a whistleblower or you've had an internal audit in some cases, that give you some evidence as to wrongdoing. Maybe a specific case of third-party cooperation in price fixing, but that doesn't necessarily share with you the scope of wrongdoing. How many other procurement bids? How long has this been going on? Is this involved the entire sales force? Is this an inherent kind of undisclosed practice, or is there something less here? So we discover as we move through an investigation typically that the scope will often and nature of misconduct is much more comprehensive than maybe initially thought. And then of course there are liability concerns. Clearly the obvious ones are, what are the criminal and civil implications, not only to the corporate entity or to the partnership, but to its various components. There may be third-party liability concerns. So liability to our business partners, to our agents, to people in the marketplace. Related to the corporate liabilities are director and officer liability. We deal a lot with D&O liability issues. They go hand in hand with investigations in many cases. And those are liabilities which will often direct a corporate entity to seek outside counsel, because there are implications to that D&O liability, not only implications, from corporate liabilities, but actual people who are managing operations in a region, whether it be, say, Cambodia, Myanmar, Laos, or Thailand, to give our examples. There may be criminal implications. They may have to appear before police. They may need individual representation. They may have to make decisions on whether they can travel freely. There are a lot of real personal decision-making inputs when we're talking about officer and director liability. And then finally, shareholder liabilities. And those are self-evident, right? There may be implications where management hasn't done enough to curtail or prevent wrongdoing or act in a responsive, objective way, comprehensive way. There may be implications for shareholder liability. Now, you've identified the need for an investigation, but it doesn't mean you will, in every case, say, well, we're going to go forward with it and this is the scope. There's always a consideration of what are the benefits and what are the pros. What are the pros and what are the cons? Some of the pros, I think, are obvious, others are less, and this is not an exhaustive list, but the investigation is documented. That's basically means you have a documented record of having acted in good faith to operate an investigation, to accumulate and summarize facts and evidence, and to make a decision. And that ultimately does a couple of things. It will allow you to be, as an organization, aware of the scope of the wrongdoing and the particulars of that wrongdoing. And where you haven't had an investigation, you will maybe be behind the proverbial 8 ball by not being fully aware of what your potential liabilities are. So there's a real benefit to having documented and understood the scope of the wrongdoing. It also allows you to determine what is the extent of compliance measures that have been in place or have been implemented, or importantly, post-investigation, what you should do to structure a more effective compliance program. And where you haven't conducted the investigation, you're not going to be aware of all the facts that are necessary, many of which only come to light through the investigation itself in order to make sound, appropriate compliance measures. And finally, and probably as important, if not more important, is it shows good faith and cooperation, not only to law enforcement or regulatory authorities who may never conduct an investigation, but to the employees and to the company itself. So really important that a company act in a way when they're investigating to show consistency of how they're treating an organizational problem, and also limits it. What it does essentially is it limits your liabilities with law enforcement and the regulators but it also encourages a better environment with your employees in directing an investigation. And where you can encourage a better environment and better morale, and we'll talk a little bit more about that coming up, you're going to have a much more smoothly operated investigation and the post-investigation climate. So what are the cons? I think the obvious ones, particularly the first two bullet points are there, right? Cost. Investigations can be prohibitively expensive. Now, again, I'll talk that it's not every investigation is of the scope that requires massive expenditures of money. It depends, again, on the nature and the scope of wrongdoing. But it's costly. Anytime you hire outside counsel or third-party forensics investigators, there are going to be costs involved. There are also internal costs to the organization. Even if an investigation can be handled internally by a compliance group or regional officers, etc., it's still a cost of resources. Not to mention the disruption that it can play on an organization itself and its employees. It impacts the ability of the organization to effectively do its job in the marketplace because there's an ongoing investigation. And invariably that investigation, no matter how well it's crafted, no matter how well the tone and communication channels are crafted, it's still going to have an impact on the organization and employee morale. Sometimes, clearly, there are difficulties with employee and third-party cooperation. With employees, you usually have an easier time getting them to cooperate through interviews, etc. But if they perceive themselves as a target, and let's face it, many of them are, and they're aware of their own wrongdoing, they may not be as forthcoming and cooperative as you would like. And there's only so much you can do there. So you have to anticipate that there are going to be difficulties. In many cases, third-party cooperation is touchy. Maurice talked a little bit about it. You can't impose your will on a third party, but it just depends on the nature of the relationship. And if it may be a relationship where there's some cooperation, but it may be that they're not willing to cooperate. It really depends. Disclosures, whether voluntary or compelled, may actually assist authorities in claims. What does that mean? It essentially means this is not all entirely likely because in most of Southeast Asia, there are not disclosure obligations across the board. And so as a result, we're talking about voluntary disclosures. If you voluntarily choose to disclose to the authorities, and sometimes foreign law may play a role in that, say for the Foreign Corrupt Practices Act or Australian law, there may be incentives for an entity to consider disclosures to the authorities. Those very disclosures could have an impact on the conduct of subsequent investigations. And then finally, this may not necessarily be a con, depending on your perspective, but when you have an initial scope of wrongdoing and you start digging in and conducting inquiries, you invariably will discover or may discover additional wrongdoing. And it may not just be the wrongdoing of the type that you have gone into the investigation seeking, but maybe other types of wrongdoing that have their own implications. And so you may have a much broader scope, bigger cost, and disruption than you had ever anticipated. So these are all things that need to be considered. But let's just assume for a minute that we're in an investigation. We've made the decision. The pros far outweigh the cons. And quite frankly, even if there are cons, we have to go forward. The important thing with the scope of the investigation is to define the engagement. Now, this is particularly important with foreign jurisdictions, more so than in Thailand or in other jurisdictions in Southeast Asia, is who is the client and who are the participants? Who is engaged with the client of the participants? So the client's engaged but has two outside counsel sources working for them, maybe a third-party forensics investigator. Does everybody sign an engagement agreement with the client, or do they go through outside counsel? These are all factors that with outside counsel are typically decided upon because they have an implication on whether or the complexity or the ability to claim attorney-client privilege should it come up. Again, less of a major concern in Southeast Asia, but it's almost always a concern for our multinational clients, and particularly outside counsel. Also, in dealing with the scope of the investigation, you have to define that scope, right? Who is responsible for the communication channels? If you're only dealing with compliance or outside counsel, global counsel, regional counsel, it's a little bit more simple operation. But you might be dealing with regional heads, regional counsel, global general counsel, let's say, as well as outside counsel, anti-corruption counsel. Or representatives. So there may be multiple inputs. It's very important to define who is the main communication source, who is directing the work, who is directing the plan, and who is ultimately preparing a final assessment. So so you need those clear communication channels. You need to define the roles and a strategic approach to that investigation. Importantly, it's also very, it's a vital component to make sure that investigators, whether they be company investigators or third parties, establish a clear tone, right? A tone of cooperation and consistency. And my experience is that where a company is consistent with the conduct of internal investigations, whether they be just for employee wrongdoing of a simple nature or more complex, it's better understood by their organization as a whole, that this is something the company does. They're doing it in good faith. It isn't anything personal. And if that's a tone, and if it's a cooperative tone, you're more likely to get cooperation from people being interviewed, employees and third party. And then timelines. Very, very important to set timelines. I am cognizant of the fact that timelines can change, but it's the best approach to at least try to keep a mind of your timelines. In almost every case, there is urgency to the conduct of an investigation. And so we have this balancing act between we need final results now and the need to conduct the thorough investigation and have a proper assessment of the facts and evidence. So the investigation process, identify and gather evidence. I won't spend a lot of time here, but it's important, whether it be electronic or traditional hard copy evidence, that you gather it, that you maintain it in a way, that you preserve it, so that if you have document retention policies, that they're maintained. If you need to have certain documentation maintained on site during the course of investigation, make sure those policies are adopted, and summarize that evidence. Proper summary is important. Identify first, and then interview potential witnesses, current and former employees. Former employees pose interesting problems because they're not compelled. Third parties, of course, and then prioritize and strategize an approach for witnesses and your evidence. When they're related, it's important. So normally what you're going to do is you're going to do some level of forensic or documentary review followed by interviews. If you do not do the former, then your interviews are largely not going to be as effective as they otherwise could be. In some cases, you may need to go back to additional evidence and maybe come back to witnesses. But it's important to at least prioritize and organize this approach. Now, where, when, and how. Very, very important. Every situation is different. This is usually a very, very sensitive subject. If you're dealing with certain employees who are maybe alleged to have been involved in wrongful behavior, you need to make sure that you understand who should be doing the interviews. Should it be somebody trusted and considered neutral in the firm? Usually, yes. Should you bring in outside counsel or outside parties? Problematic. Oftentimes, by bringing in outside counsel, you create an environment of tension and maybe even lack of cooperation. So it needs to be assessed carefully, but there are advantages to having counsel involved at some level, even if they're not conducting physically the interviews. Tone, as I mentioned before, and the process are key in order to maintain as low a tension level as possible, and to maintain a level of less disruption to the organization. Very, very challenging. I understand that. Who are the participants? Obviously, I've talked about that. It needs to be mapped out. And often every company has a different approach. Outside counsel might have different recommendations. It is inherent that that be thought of and planned accordingly, and also take into account who are the people with whom we're dealing, what are their personalities, what is the organization like, how shall we proceed to the most effective way possible. Reporting and recommendations. So you've done your interviews, you've done your collection of evidence. This might typically take weeks in a fast investigation. It may take longer in a more comprehensive investigation, but ultimately you assess the facts and evidence, you summarize them, including testimonies, you focus on that evidence, you apply relevant laws and regulations, and importantly, company policies, regulations, and objectives, and then ultimately reach a recommended action. That recommended action might be, for instance, the evaluation of the need for terminations under the laws of Laos or Cambodia or Thailand, for example, whether recommendations for written warnings are in order, or whether there is a no termination recommendation, but some other sort of remedial actions. It usually involves detailed legal advice on what you can and cannot do in the labor and employment practice. Recommendations on disclosures and the implications of those disclosures. Recommendations on a compliance program. And this isn't a discussion on compliance. Maurice made some good points on compliance, but what I would just say here is that many organizations have robust global compliance programs, well thought of, regularly updated at a global level. No shortage of resources and thoughtfulness going into them, but perhaps not enough focus and investment of time on regional application, on taking into account language and customs and local training. And I see quite regularly that this is an area of failure. So it's really important that that compliance measures be focused on not only the policies, the global policies of the organization, but on the local laws, regulations, and customs and practice of an organization and their subsidiaries. Very, very important. I would say here that many companies for whom we participate in investigations have already in place compliance programs, and in many cases robust compliance programs, but there have been inherent failures in getting the local employees, the local organization, to buy in to those programs and to understand the importance of those programs. So very, very key. So again, post-investigation actions for compliance, right? I've already mentioned some of these. You need to evaluate the report. Sometimes the report involves input from a client, questions from general counsel and the compliance officers, questions related to the assessment. Oftentimes clients may not like what they hear in an assessment. It's important for counsel, or at least for people who read a report from counsel, understand the pros and cons of accepting the recommendations, or if they don't accept those recommendations. Actions on employee discipline. Many of our clients are more than capable of handling the HR side of action and discipline, have policies already in place, but it just needs some legal assistance on the legality of actions and the process in a local jurisdiction. Business practice modifications or eliminations. You know, oftentimes it may result in real seismic events and changes for a company that alter the way they do business. So in a case of in the sales force, where they may have cultural experience dealing with outside third-party bidders, where that action is illegal, they have to totally change their approach to procurement bidding. And so that may have a significant effect on the business moving forward, but if they don't change it, there could be even more drastic changes and effects on the company. Again, consideration of voluntary or required disclosures. It depends on statutes and regulations. and also on an assessment of potential liabilities. Again, most of the time here in Southeast Asia, the decisions are not to disclose, but to be robust in implementing and documenting the investigation and post-investigation policies and procedures. Again, you might need to evaluate or modify, otherwise adapt an existing compliance program. As robust as it may have been, it obviously wasn't enough to change the wrongdoing, and so it may be a focus moving forward on a more involved or adapted compliance program. And then finally, active implementation and regular audit assessments of those plans. It's again not enough just to have a great plan in place if you're not evaluating it regularly, training regularly, looking at its compliance with relevant laws and practice, and looking importantly at the local and regional customs. And if you do that quite regularly, then all of the costs of having to conduct an investigation to begin with are going to be reduced, because in the future, the likelihood of a comprehensive full scope investigation being necessary are going to be less. That's it for me. I appreciate, I did go over by about 5 minutes. I apologize.
Now I'd like to introduce our next speaker, Jay Cohen from Teely Keys and Gibbons Cambodian office. Jay is a partner and director at the Cambodian practice, leading the Phnom Penh office's commercial and intellectual property practices. Based on his client service and legal expertise, Jay is ranked as a leading lawyer in Cambodia by Asia Law Leading Lawyers, Chambers, Asia Pacific, and the Legal 500 Asia Pacific. Thank you, Jay.
Julie, thank you for that introduction. So today we're going to talk quickly about the anti-corruption legal framework here in Cambodia. So we're going to cover 5 topics today. So we're just going to jump into it. We're going to start with talking about the background here in Cambodia. So with this slide, we just want to really set the stage to sort of understand what's the perception of the corruption environment in Cambodia. So Transparency International has a corruptions perception index. So it's perception based on surveys. So Cambodia ranks 160 out of 180 countries. So that's at the bottom. So clearly, corruption is potentially a serious issue here in Cambodia. If you look at who it's tied with, is with Chad, Eritrea, Iraq, the Comoros Islands. Within Southeast Asia, it is scoring below Thailand, Vietnam, Laos, and Myanmar. So clearly, it's an issue. At the same time, though, if I had to be optimistic, I would say, yes, corruption is potentially endemic in Cambodia. At the same time, though, I often tell investors it's not so bad. And when I say that, what I mean is, of course, companies have a choice. So clearly, I think facilitation payments is an issue in Cambodia, but you don't have to pay them. And of course, companies have a choice. They can implement strong anti-corruption policies, and then you have to be prepared. Applications might take longer. Applications maybe will have to be revised or submitted multiple times. But of course, you have a choice in the matter, and you don't have to participate. And you can certainly do business in Cambodia without paying those facilitation fees if you are committed to carrying out business without any sort of corruption. In Cambodia, the main institution that handles anti-corruption matters is the Anti-Corruption Unit. So it was established as part of the anti-corruption law. It's the main enforcement agency. They handle all investigations and prosecutions. So admittedly, enforcement is relatively uneven. Recently, pretty much most or all the prosecutions have dealt with government officials. So the Anti-Corruption Unit does not only focus on companies, actually most of their activities are really focused on government officials. So I think that's something to keep in mind when we also think about maybe the likelihood of enforcement actions against private companies. As for the legal framework in Cambodia, you have the domestic anti-corruption legal framework. So we will know that Cambodia has joined some high-level conventions, like the UN Convention Against Corruption. But then when you look at the Cambodian domestic framework, you're really looking at 2 separate laws. The first is a criminal code, and it was actually enacted in 2009. And actually most, and this is important to note, most of the corruption-related offenses can be found in the criminal code. At the same time, the Cambodian government also enacted the law of anti-corruption in 2010. So some people might wonder, if they have the anti-corruption law in 2010, what did that add to the framework? Well, again, most of the corruption-related offenses are in the criminal code, but not all. So the anti-corruption law did expand some of the anti-corruption offenses, but really the anti-corruption law established the anti-corruption unit and really put in a whole framework for the Cambodian government to, for people to report wrongdoing for corruption, and then for the Cambodian government to investigate it. And then again, it did expand some of the corruption-related offenses, and it did clarify some of the penalties for carrying out corruption, and also it kind of clarified some of the penalties for companies if they engage in corruption. For the anti-corruption law, as I said, it establishes the anti-corruption unit. So we kind of covered these points already. So one of the key issues is, of course, it's like, what is corruption? How is it defined in the local market? And I will say this is really an important question, because I'll say in some jurisdictions, like the United States, there's a Foreign Corrupt Practices Act. Some things such as facilitation payments maybe won't be, some things like facilitation payments, they're only illegal under US law if they're illegal under local law. So in that sense, it's really important to understand, well, how is corruption defined in Cambodia, because it may impact your country's law as well. Like under Australian law, it might be relevant. So in Cambodia, corruption it's a very broad definition, the act of offering, accepting, or soliciting a bribe. And it's important to note that a bribe can be a gift, a present, a promise, or any other sort of benefit conferred to induce action or inaction. So it's a very broad definition. And then it's important then to look at, of course, what's a gift, what's a benefit. So as for benefits, you can sort of see off the slide, it's a really broad definition. I think that's really the takeaway here. I won't read off the slide, but when you really think about what corruption is, it can be really broad. Benefits can be gifts, all kinds of different things. So I think if you're also looking at investigations, it's not just following cash payments. It could be other things as well. And then another issue becomes, from a Cambodian law perspective, when does a gift become a bribe? And this is particularly important in sort of like the hospitality context, or maybe giving traditional gifts. Because sometimes for Cambodian holidays, it's quite common to give certain kinds of gifts, maybe for Khmer New Year, things like that. So, there is like a definition of a gift. Any property or service given to or for the benefit of a person that is not regarded as an agreement and given as a gift in acceptance with customs and tradition. So again, it's sort of interesting to know that they do allow for some gifts with custom or tradition. So again, during some of the Cambodian holidays, some gifts are not uncommon, and companies might give some gifts. But then again, I think it's really important to keep them of like lower value, to really try to get a sense of these just sort of like traditional kinds of gifts, or is this something excessive that could potentially be considered a bribe? It is interesting to know that for anti-corruption unit officials, any gift in value over $25 must be returned. So that's actually a benchmark. Only it applies to ACU officials, but I think it's relevant to give you a sense of, small value gifts might be considered consistent with customs or tradition, but like higher value gifts would probably not. One of the issues to also think about under the anti-corruption law is it has to do with commercial bribery. So, one of the questions is private bribery illegal? So we'll certainly talk about, bribing government officials is illegal, but is private commercial bribery illegal? And the answer is yes. I mean, under the anti-corruption law and the criminal code, commercial bribery is also illegal. Gifts can also lead to corruption prosecutions. So the potentially you're looking at prison sentences and also like monetary fines. In Cambodia, I will note obviously that the criminal prison sentences would be very significant. Often the monetary fines are comparatively low. So if you look at a $250 to $1,000 fine is relatively low, but certainly potential jail sentences would be very significant. I think it's also important for companies to understand under the anti-corruption law, there is corporate liability. So, companies can certainly be responsible for acts of their employees, and this can extend to, employees, representatives, also potentially third-party contractors. So for third-party contractors, that would be a case where, for example, a company knows they want to apply for, say, visas and work permits for their employees. So, and they know that if there could be some facilitation fees, or they really want to speed things up. So they think, oh, I could go to the ministry myself and it might take a long time. I want to speed things up. So I'm going to use a third-party contractor, some other company, and I know I'm going to pay them a fee, and they're the ones that are going to pay the under the table fee. So technically under Cambodian law, that's illegal. You can't use third-party contractors. You can't turn a blind eye and let them make the payment on your behalf. So that's all potentially illegal in Cambodia. Some common issues that companies are likely to face in Cambodia. The main one is really facilitation payments. So I think that's really the main concern. There's a lot of small fees that are often sought in order to speed up application processes. So just to be very clear, that is considered bribery under the criminal code and the anti-corruption law. So I think it's something that companies need to really be aware of. At the same time, when I said at the very beginning that, yes, corruption is endemic, that's often because of facilitation payments, but at the same time, companies can resist. You can certainly do business without making those payments. You just have to be committed to doing so. And then be prepared to take more time in submitting applications and then in dealing with the government. For hospitality, we also want to highlight, there are no safe harbors. So potentially any hospitality could be considered corruption. At the same time, I think on a sort of a practical level, people need to ask, is the focus of this hospitality, is it business or leisure? Are friends and family invited? Or are these sort of typical kinds of meals? You have a conference, you provide food and beverages during that conference. It's a work-related dinner, and also to consider whether the amounts are excessive. I will say the Cambodian government does have certain internal guidelines for how much Cambodian government officials can get paid if they are staying at a hotel, what are their meal allowances. Those are actually sometimes good to just keep in mind. Generally, if you're below those thresholds, that would be considered reasonable levels of hospitality in the business context. Under Cambodian law, another question might be, are anti-corruption programs required? So under Cambodian law, there is no requirement to have any sort of internal anti-corruption program. At the same time, the anti-corruption unit has issued a guidebook that can help companies implement anti-corruption programs. So again, nothing is required. There is a guidebook, which may be useful for some companies if you're interested in implementing it, but it's not mandatory. So in that sense, companies have a lot of discretion in terms of what sort of programs they really want to implement on the ground in Cambodia. As for best practices, the first one I want to start off with is, the anti-corruption unit has a process where companies can sign an MOU with the ACU to evidence their commitment not to engage in corruption. So I think this is actually a very powerful tool. One, it's a commitment you're making to the Cambodian government, I won't engage in corruption. And at the same time, once you have the certificate, it can be helpful in some situations. If the company is coming under some pressure to maybe make some sort of facilitation payment, they can show this certificate to say, look, we've committed to the ACU not to make any payments. We really can't do this. So I think that's actually a really powerful tool, and I would really encourage all companies to look into this. Also, I'll say for Tilaki, we are the only legal services provider in Cambodia that I'm aware of that has signed an MOU with the ACU to show this commitment not to engage in any corruption. And we have found it useful in some situations. So I would really encourage companies to look at that. That's really useful here. Otherwise, and I know this has already been discussed, but companies can also have within their own internal guidelines. They can also ensure that anti-corruption provisions are just part of their normal guidelines. That would certainly be a best practice. And I know some other speakers have already talked about some of these issues today. One thing we'd like to highlight, certainly under the anti-corruption law, there are provisions that allow people to make complaints and to report corruption. I do want to highlight, though, and this is a bit of a cautionary note, under the anti-corruption law, it does criminalize whistleblowing if allegations of corruption contain disinformation or defamatory statements. So it's a bit of a hot issue because the anti-corruption unit, of course, has discretion to prosecute any sorts of to investigate and prosecute any sort of whistleblowing. So potentially, again, if any of these statements made in a complaint are considered defamatory, the whistleblower could be subject to punishment. So I think before companies report, they really need to give some careful thought to make sure that their allegations are very well documented. Otherwise, potentially, for companies, there could be some punishment for them. So I would actually say if you're a company, you're thinking about reporting, you might want to talk to some legal counsel on that point. Lastly, we'll talk quickly about some legal penalties. So they're up on the screen. We'll just note, of course, for bribery in Cambodia, there are penalties. They can range from 6 months to 2 years for commercial bribery, but if you're doing public officials, the penalties are much more severe. In practice, we've really seen the ACU focus on government officials that have committed various acts of either bribery, particularly abuse of their position. And we haven't seen it so much focused on the private sector, but potentially it's there. For companies, again, as I said, we haven't really seen much focus on the private sector, but companies could face a number of actions. The most serious would be dissolution, but there are other things: fines, judicial supervision, being prohibited from engaging in certain conduct or certain activities, particularly if you're looking at things like the banking sector or other sectors. You could be prohibited from engaging in certain activities. So there are a number of serious penalties that could affect private companies as well. That brings me to the end of my presentation. I want to keep it short and high level, so I'm certainly happy to answer any questions you have at the end of the presentation. Thank you, everybody.
I would now like to introduce our next speaker, Dino Santeliello, who will cover this subject from a Laos standpoint. Dino is the head of Teely Key and Gibbons office in Laos, and he has a broad experience across many fields of law, including intellectual property, privacy and data protection, corporate and commercial transactions. Dino advises both domestic and international companies, and his legal expertise is recognized as a rising star in Asia Law Leading Lawyers 2018 and as a leading lawyer in the Asia Pacific Legal 500 2019. Thank you, Dino.
So let's jump directly to the presentation, which will be more or less similar to what Jay already introduced you to about. So about a quick overview of the country. So as Jay put it, the corruption issues is actually an issue which is very endemic in the region, and this applies also to Laos. In the Transparency International Country Index ranking, Laos is pretty low, although a little bit better maybe than some of the neighboring countries such as Myanmar, or Cambodia specifically, but far behind other countries such as Thailand or Vietnam. The good thing is that this is very well known by the local government, and this is also very well acknowledged publicly by the government, which has tried to implement new measures and also to work with international organizations for the past few years in order to raise the standards of regulations, laws to combat corruption in Laos. And maybe there were some fruits out of it recently, because maybe for the past 2 or 3 years, we have been able to see some media covering corruption issues in Laos throughout the country, not just specifically in the capital. But the thing that we can also witness is that most of the time these issues covered would be about public official. We were caught from wrong behavior, having corrupted actions, and not much about the private sector. And this also translates into the regulation. Most of the regulation, most of the provisions in the Lao legal framework will tackle actually corruption among the public sector, but less in the private sector. For the supervisory agencies combating corruption in Laos, I have chosen to mention two of them, but actually there are many others. But the State Inspection and Anti-Corruption Authority, which was set up according to the law on state inspection, is actually the governmental agencies which is in charge to control public officials who may be suspicious of corrupted action. And also the Anti-Money Laundering Intelligence Office under the Bank of Laos, which is the Central Bank of Laos, to which actually many of the suspicious transactions, which may cover actually corruption acts, but bribery, for instance, more specifically, may have to be reported to. So those two agencies are very much involved relating to the combat of corruption in Laos. Now about the legal framework. So similar to Cambodia, Laos has ratified in 2009 the UN Convention Against Corruption. But other than this, the main piece of legislation are the Law on Anti-Corruption of 2012 and the Penal Code. So for the Penal Code, actually, this is a very important piece of legislation in Laos. First of all, this is the first penal code ever in Laos modern history. And this penal code has embedded most of the provision contained in the anti-corruption law to be included also in the penal code. And the good thing is that, in my opinion, the penal code makes it easier to implement the sanction contained in the anti-corruption law. So accordingly, the Lao authorities has provided themselves with a new tool to combat corruption in Laos since 2018. So what is corruption under Lao law? So this is actually pretty well defined in the penal code, which define corruption as a behavior characterized by one of the following acts. This is also important to note that the list is exhaustive. So here in front of your eyes, you have what the Lao law deem as a action of corruption in Laos. For the purpose of this presentation, we'll be focusing on giving and receiving bribes. A bribe, first of all, is absolutely prohibited under the penal code. So all employees are actually prohibited from offering, promising, soliciting, or even indeed accepting bribes. And it is important to note that the term employee is not very well defined and includes all employees from the public and the private sector. So what a bribe may consist of. So a bribe may be indeed money, but also a set, thing, or any other benefit. The problem is that any other benefit is not very well defined, but it can certainly include any type of entitlement, any type of services, any type of gifts, any types of reward given by an individual to an employee to perform or not to perform an action for the benefit of the bribe giver. One of the point which is very important is that to be sanctioned of a action of corruption or to give a bribe or receiving a bribe does not need to be made directly, which means that the bribe may be provided actually via an intermediate, and the bribe giver will be also sanctioned according to the penal code the same. Also, private to private bribery is actually something that can be sanctioned according to the penal code. Corporate liability. So that's actually a novelty of the penal code of 2018 in Laos law. So accordingly, a company, a legal entity may be sanctioned for receiving or giving bribes under the penal code. Three conditions must be made. So first of all, the offense must be committed on behalf of the legal entity, then for the interest of the legal entity, and eventually the offense is committed under the supervision, management, and decision of the legal representative. Once those three conditions actually are met, then a company may be sanctioned for receiving or giving bribe under Lao law. So some of the common issues that we have been facing with whenever we had to advise our client in Laos, about the same as Cambodia actually. And the first question we have often is about facilitation payments. So short answer is no, it's not recognized in the Lao law, and it's not possible to make facilitation payment. It's not something legal. Accordingly, every type of facilitation payments fall under the definition of bribe under the penal code, but also under the anti-corruption law. For gifts, so for gift, there is no specific regime relating to gift. Accordingly, it's a lot of interpretation, and as long as a gift may influence the decision for the benefit of the person who is giving the gift, then it could be construed as other benefit, as we've seen just earlier relating to the definition of a bribe. There is no also threshold where a gift may be exempted from being defined as a bribe in the Lao law, and there is no also threshold of value, as we've seen for Cambodia, for instance, where a government officer may have to refuse a gift if the gift exceeds certain value. The only guidance we have is actually in the decree on declaration of assets, which oblige every government officer to declare any type of assets they have, they earn on a regular basis. These public officials must declare any gift or rewards whose value exceeds 5 million kips, so about $530. So this is the only guidance we have. It doesn't mean, though, that for gifts below that amount of money, this will not be considered as a bribe, but definitely if the gift exceeds that amount of money, there will be a strong suspicion that this may be considered as a bribe given to a government officer. Anti-corruption programs in Laos, so the short answer would be no. There is no requirement to actually implement any type of anti-corruption programs in the Lao law. Recently, there were the guidelines on corporate governance for listed companies issued by the Lao Security Commission. For now, they are not yet enforced. They will be enforced in the next 3 years, but according to the guidelines, the company listed in the Laos Stock Exchange market must implement mechanisms to prevent fraud, and which actually could be understood as to prevent any act of corruption among the listed company as well. And finally, there is also a mechanism that must be, a program that must be put in place for financial institution and some other very specific legal entities in Laos, which must report actually suspicious transactions to the anti-money laundering intelligence office we've seen before. And these suspicious transactions actually are clearly bribe are clearly mentioned as a suspect transaction if those acts are suspicious to suspect to conceal any money laundering action. Disclosure of information during investigation. So what happens if your company is actually under investigation by the Lao authorities? The two agencies we've seen before, the State Inspection and Anti-Corruption Authority and the Anti-Money Laundering Intelligence Office, have broad powers to actually compel every legal entities to force them to hand over any information you may have. So definitely the local authorities can ask any type of information if there is a investigation ongoing. And I believe it's very difficult to for the legal entities and private companies to oppose anything in this regard. The law is very clear in this respect, and these two agencies will be able to ask for any type of information they deem relevant for the investigation. So recommended best practices. I think everything which was said for Cambodia applies the same to Laos. Indeed, prevention is the most important thing to do when investing in Laos, when carrying out a business in Laos. It would be also very important to identify the risks. Depending on your activity and the position of the employee, the risk may differ. For instance, you may have employees who stay in the office a lot, and those employees will actually have to come and go out of the office and have regular negotiation, regular discussion with government officers. Maybe there will be an emphasis to make on for these employees and elaborate internal guidelines, anti-corruption policies, but also maybe embed those policies and guidelines into the working rules of the company. And we believe also it's very important to develop any clear reporting procedure in the event that some bribery or corruption acts were identified among the company. The sanction. So for sanction, they are pretty heavy regarding for individuals specifically, because life imprisonment is definitely something provided under the penal code, but also a fine representing 1% of the total damage value as per the penal code. So we don't really know what means damage value, if it means the value of the bribe or more than that. And for legal entity, it goes the same, fine. Indeed, no imprisonment, but dissolution, business suspension, or prohibition from mobilizing from with, for instance, through loan through banks, are another option for sanction provided under the penal code. So my presentation was pretty short, very concise. So if you have any question that you would like me to answer, I would be happy to answer any question you may have. Thank you.
Dr. Ross Taylor from Tileki and Gibbons Myanmar office. Dr. Ross is a counsellor in the corporate and commercial team of Tilek and Gibbons Laos, Myanmar and Thailand practices, one of the most experienced and versatile foreign consultants in the region. Ross is particularly noted for his ability to handle commercial contracts with complex financial structures, such as high-value banking and financial transactions, and complex technical specifications, such as aviation, infrastructure, and fintech deals. He has extensive experience in banking and finance, mergers and acquisitions, joint ventures, energy and infrastructure projects, real estate and regulatory compliance in tightly controlled industries, accrued over nearly 2 decades of experience in Southeast Asia. Thank you.
So the situation in Myanmar, this will be very high level because you'll not be surprised to hear that the situation is pretty similar regionally, perhaps a little more similar in Myanmar to Cambodia than to Laos, but there are still great similarities. So we're following the same agenda, so I won't dwell on that. But the overview is the main supervisory agency is the Anti-Corruption Commission, which was created by the anti-corruption law. I have to say that the Anti-Corruption Commission in Myanmar is not very active, although there have been a number of prosecutions more recently. Transparency International ranking is a score of 28, which is very low. So we're very low on the scale where you want to be high, and we're very high on the scale where you want to be low. So the legal framework, the main framework is the anti-corruption law, which has been substantially amended. The important changes that have been made during the course of amendments to the anti-corruption law is that the original definition of corruption was the misuse of his post by the competent authority, or another translation put it, by the authorized person. So it appeared to be only that some kind of government official was able to commit corruption, although it wasn't quite clear who the competent authority was or who the authorized person was. But that has now been changed. So if you look lower down the slide, corruption can be committed in red by any person. So it seems clear now that corruption can be committed in the public sector and in the private sector. So there's no doubt about that. And corrupt means accepting the consideration or appropriate value for the purpose of corruption without paying or given currencies, properties, presents, service fees, entertainments, and other illegal benefits. So as in Cambodia and Laos, the definition of what is corrupt is very wide indeed. So therefore, corruption can be committed by any person. I've mentioned that it's broad enough to encompass bribery in the private sector, although the anti-corruption law does not appear broad enough to cover third parties, unlike some of the other countries we've discussed. So giving money to someone, knowing that they will use that for an under-the-table payment, as Jay said, would not appear to be covered by the anti-corruption law. And another point to be made is that the Anti-Corruption Commission can take action on its own if it has reason to believe that someone is guilty of corruption. So common issues, rather like the other jurisdictions, facilitation payments are commonly demanded by government officials in Myanmar. One of the major problems is that facilitation payments are not seen as corruption culturally. They're not seen as being bribery. And unfortunately, if they're not paid, there will be a delay. But the point to note, as Jay also said, is that government officials, if they're not paid, when they're pressurized and argued with, they will eventually perform their task. There is only one set of guidelines available in Myanmar. These are rather old now, that they were issued by the previous government in 2016 that actually name figures, name amounts of dollars that are acceptable, or amounts of Myanmar chat that I've converted into dollars for you. The basic principle is any gift to government officials is prohibited. So that's absolute. However, there are a couple of exceptions, and these are gifts to a value under US dollars 65, or gifts on special holidays, for example, Christmas or Tinjan in Myanmar, which is the water festival, again to the same value. Interestingly, a much, much lower value than the figure of approximately $500 stipulated in a slightly different way under the Laos regulations that Dino mentioned. There is no law to force companies to have a code of conduct or anti-corruption measures, but there was a notification passed by the Anti-Corruption Commission that establishes principles for a business to have a strong code of ethics and internal controls. So an effective policy from top management, risk assessment, measures to check vulnerable areas, anti-corruption measures with business partners. As Morris said, these could include contractual terms or provisions that there could be due diligence or audit of business partners, accurate books and accounting records, human resource policies, reporting mechanisms, and periodic review of such measures. So there is guidance, but this is not law. Then question whether there's a duty to cooperate. Well, basically the rule is you cooperate or else. There are no direct disclosure obligations, but if you try and conceal or destroy or alter anything to avoid action, then there's a heavy prison sentence that could be attracted. So what are best practices? Morris and the others have really recommended them already. So I'll be very brief. Facilitation payments will be demanded. There are severe penalties for bribery, although I do not know of any case of enforcement in the private sector. I only know of cases of enforcement and prosecution in the public sector. Nevertheless, the penalties are so severe that you should never be tempted to make even facilitation payments. It will slow down approvals, there'll be more hassle, but they will eventually be granted. And in addition, there should be an up-to-date anti-bribery policy. So the final note is that the basic penalty is up to 7 years imprisonment or a fine. So not as severe as Laos, but nevertheless potentially a significant period of imprisonment. And that's all I have to say about Myanmar. Thank you very much.
Thank you very much, Dr. Ross. Sorry, I've got an echo coming back to me there. So I am mindful of the fact that we have run a little bit over time, but we do have some questions in the Q&A, so perhaps we'll make it a shorter Q&A session. The first one, maybe I can ask Jay to answer it. It says, the question posed is, in the case the employee breach the internal rules of company misconduct, and its fault concerns criminal offence such as embezzlement or corruption, but a minor amount, what should the company do? Should they go to the police or start an internal investigation first?
That's a really good question. In a very general sense, and if any employee, so that's a very good question. So in a general sense, if any employee commits an offense, I think the company has to make a determination. Also, do they want to terminate that employee? And if they want to terminate that employee, then they need some sort of basis for doing so. So I think in that sense, it certainly leads towards like doing an investigation to make sure that they have proper evidence of the Employees Act. And then they would have a decision to make whether they would want to necessarily go to the police or the anti-corruption unit. I think for the vast majority of companies, if it's for small amounts of money and it's breaches of certainly Cambodian law, but also of internal rules, I think most companies would tend to simply to terminate the employee. So the investigation would support the grounds for termination, because breaching law would be an act of serious misconduct under Cambodian law, and then the employee could be terminated. And in the event that the employee ever challenged a termination, then the investigation would support the reason for the termination. So I think it's actually quite rare to go to the ACU or to go to the police, unless it's really perhaps a more significant amount.
Hi, this is Michael. I'll just add on to that. I think across all most jurisdictions, when you have the criminal wrongdoing of the nature, regardless of the amount, you're talking about a serious wrongdoing that is a justification for termination for cause. I don't think any of our jurisdictions here would vary. So again, as Jay said, it really depends on what does the company want to do. There are no specific mandatory disclosures that the company has to law enforcement to report it, but depending on the wrongdoing, some companies might actually want to press charges for the embezzlement, might want to seek compensation, etc. So it really depends on the discretion of the company, but almost assuredly grounds for termination and no mandatory disclosure.
Thank you very much. The next question asks, may I clarify again the meaning of D&O liability? Which presenter covered D&O liability?
That's me. It's Michael. The
Okay,
question is
Michael.
a definition of D&O liability.
Yeah, the meaning of.
Yeah, it's
Which
essentially, it's just a, I'm sorry to assume that that acronym is, well, it's actually not an acronym, but that shorthand is known by all. I mean, it's director and officer liability. And so what it essentially means is that people in positions of authority within an organization may in some cases be liable for their own actions, or in other cases, the actions of people for whom they are responsible. So I'll give you an example. In Thailand, for many, many years, there were well over 100 specific statutes that presumed officer and director liability for a variety of criminal wrongdoings. For example, under declaration of value in customs importation, but a lot of other matters, submitting of certain accounting and financial statement forms, etc. And oftentimes, law enforcement would include the named country general manager, for example, in a criminal charge or an investigation against the company, but also against the individual who is responsible for running that company. So when we talk about D&O liability, we're talking about not only direct liability of the officers and directors and management, but also the liability for management of the company. So that's what we're really talking about. Somebody can do something at an employee level that could potentially affect the liabilities of officers and directors.
Okay, thank you. And the third question, which will be our last question, I think is again directed at you, Mike, where it's saying, given T&G's cumulative knowledge regarding corruption, has there been any continuous attempt to work to ameliorate corruption with the proper authorities? There is a desire and need for a practical, applicable process to tackle the problem over time, speaking from Thailand's perspective.
Let me make sure I understand the question. Is this a question? I might ask you to rephrase it. Is this a question about, has there been a trend of more active involvement of employees and other people in positions of influence to root out and report anti-corrupt behavior? Is that the question?
I think the question is coming from the perspective is the firm relaying information? Is there a move to try and root out corruption in Thailand, i.e. the law firm working with the government? I think that's what the gist of the question.
Yeah, I mean, it is a trend question. I would say that this comes from my involvement in anti-corruption and white-collar crime in Thailand for upwards of 16 years. Certainly, the short answer is, I think at the law enforcement or regulatory level, there's no doubt that there has been a move towards more active implementation, funding, and enforcement. Now, the practical reality is and a lot of people who are cynics would suggest to you that enforcement hasn't substantially changed. While the government might be able to point to thousands of active investigations, hotlines, encouraging whistleblower activity, etc., the actual number of cases being filed and adjudicated isn't substantially higher over the years. But nonetheless, I think extraterritorial anti-corruption laws and Thailand's commitments have changed and have had an influence on our statutory regime, and to some extent the Anti-Corruption Commission, Counter-Corruption Commission in Thailand. In terms of, are we seeing that result in much more active anti-corruption activities at the business level of participation and with counsel like ourselves? We're certainly very active in trying to counsel and clients on the risks and the responsibilities that they and their employees have. I think a lot of particularly multinationals and regional companies have got a lot more focus and a lot more attention because the laws have changed a little through the years. But I would not go so far as to say that there has been a substantial change in attitude over the last 16 years.
Okay, thank you, Michael. One last question for Dr. Ross. It's saying recently, following the military coup, there has been arrests of citizens in Myanmar. They may be released following the payment of a fee. Is that considered a facilitation payment or a bribe?
Well, facilitation payments are bribes, so it's a bribe. But it's very distressing to hear that. But it's distressing that they were arrested in the first place. I'm commenting, if you're interested, on the situation in Myanmar since the coup. The information that I have is that the requests for facilitation payments and the amount of the facilitation payments has actually increased since the coup. So there's been bribe inflation.
Okay, bribe inflation, not a good positive move. Okay, I think. Okay, I am mindful of the fact that we've run over a little bit, but I want to thank all the speakers and everyone who joined us for this really informative session. And a recording of the presentation will be available later. And Auscham Cambodia will post the recording onto their website. Thank you very much.